Doug Rohan joins the Big Mountain to talk the ACC FSU lawsuits. Conference realignment and the ACC lawsuits are always in the news, so we're back on the Big Mountain to dive a little deeper. Hey, it's great to have you back on the mountain. I am JY. This is my good friend Steve. We mentioned we were going to have a very special guest join us here, and we are doing that on this episode, Doug Rohan, who has covered this from the very beginning. And without further ado, Steve, let's get to it. Let's bring him in and we'll have some discussion. All right. Well, welcome, Doug. Thank you for joining us. Can you just, tell our viewers just a little bit about yourself? What do you do? How can they find you if they want to maybe become one of your clients? And what got you so involved in this Florida State ACC lawsuit?
Well, thank you all both very much for having me on here. It's been a lot of fun to watch this process just explode in the national spotlight. And your show is one of the ones that was brought to my attention by YouTube. And I'm glad they did, because I've been watching religiously ever since that's happened. And you guys have done a great job. But I do have my own law firm, Rohan Law, in Atlanta, Georgia. And I am limited to practicing in Atlanta, Georgia. And obviously, I know that our message has gone nationwide, and that's fine, because at the end of the day, I am a Florida State fan. I am a homer. I'll admit that I'm an FSU fan that happens to be an attorney, but I wanted to be objective and critical of this process as it unfolded. I knew that I was going to be digesting all of this information. So while it has been a lot of hours and a lot of passion poured into this, I also enjoy educating people on the law. When my clients come to me for either a work accident or being arrested in a criminal defense matter, one of the things we do is we sit down and explain to our clients why they're going through the process they're going through, what the potential consequences are, and how the law applies to them. So after practicing for 20 years and running my own law firm for 10 years, we've become well versed in how to talk to people in everyday real terms about what the law means to them. And so I get to marry law and Florida State, my two passions, together in this labor of love that has now brought me to your show.
I'll follow up with that. Did you ever think, maybe before the last 6 to 12 months or so, that you'd be able to marry that up the way you have here over the last couple months? I mean, it's crazy what's going on. So it seems like so quickly here with the ACC and FSU.
No, in fact, we'll pick the first scab right away, and that's dealing with the college football playoff snub. The first tweet that I had that went viral, which, please, by the way, that's where you should be following me and engaging with me, is on X or Twitter at Rohan Law PC. But I posted right after that happened to President McCullough that I wanted to see lawsuits. I wanted discovery. I wanted to find out what kind of emails were being exchanged in that college football playoff committee room. And somebody was like, well, what kind of litigation? I was like, I don't know. That's not my area of practice. I don't do that. I just know that I want to see some discovery. And so here we are, 6 months later, 4 months later, and we are finding ourselves in the thick of some discovery. And it's been a lot of fun. So no, This isn't my area of expertise, and I'm truthful about that. I'm honest about that. What I tell people on other shows is I'm not telling you where the bus is going. I'm not driving the bus, but I sure as hell can point out the window and tell you what's happening as we drive by it. So I'm here to explain what has happened, perhaps some potentials as to what's going to happen, but really I'm learning as this is going along. And so all I'm doing is I'm digesting the information and then regurgitating it, just like I did in any of my law school classes as I was working my way through that.
Well, I can just say, Doug, just like you and I talked a little bit off camera, both JY and I have been following you on Twitter, on X, and we both really enjoy following you. And if that was your intention, to be able to help people understand, you've done a great job. We've really enjoyed following you, and it's helped us, informed us a ton. And so I'm sure there's a lot of people out there that that you've helped understand this case and just really helped just kind of generate interest. And there's already interest there, but you kind of gave it a direction. So I think we appreciate that, and I think a lot of your followers do as well. Yeah. For sure. Well, let's dive in. We've got about 5 planned questions here, and we'll just kind of meander wherever we want to head with these. The first one, we've now finally had hearings in both states, which is
great because the rubber's meeting the road here finally after a lot of this back and forth motions and paperwork and all that kind of stuff. So are you surprised at all, given where we are right now, that it appears that both cases, the one in North Carolina and the one in Florida, look like they're going to be happening for the most part at the same time? Are you surprised by that at all?
I don't think anything that has happened so far has been a surprise. Let me push back and say we haven't had 2 hearings. We've had 1.5 hearings.
True. Yes.
The judge in Florida is much more, Judge Cooper is much more deliberate and we will say not disorganized, laid back, relaxed. He's a lot more casual in his presentation and in his inquiry of the process. So as a result, what was supposed to be an 1.5-hour hearing lasted 7 hours, and we didn't get through anything. And so April 22nd, we're going to be back in the courtroom to address the rest of the case. But yes, I am very, I wouldn't say pleased, but unsurprised at where we are right now. The North Carolina judge, Bledsoe, believes this should be a North Carolina case. Florida Judge Cooper believes it should be a Florida case. That's not surprising in any respect. What is surprising is that nobody is able to determine what is going to happen. Nobody has been able to consistently state what is the game plan going forward. Is this going to be a federal case? Is this going to stay in the state? Do we have 2 parallel cases being tried at the same time? That's a terrible waste of resources and judicial. It's not judicially efficient, which the system generally likes. But yes, that appears to be where we're heading at the moment, is 2 parallel litigation tracks.
Yeah. And it gives us a lot to cover, that's for sure. We're Big Mountain or Big Ten and Mountain West focused, and we have episodes coming out on this ACC stuff all the time because with it happening in 2 different states and 2 different courts and motions for this and appeals for that, and we'll get into some of that in a little bit too. But we covered the pack for a little while, and you said it at the time that that's child's play if anything were to progress with the ACC, and here we sit with the ACC, and it's hot and heavy. I want to ask you real quick back to the North Carolina hearing, and specific to the contracts. A lot has been talked about these contracts being, or these agreements being, North Carolina contracts. And I think that's what the judge Bledsoe kind of ruled on, and he thinks it's the correct jurisdiction because they're North Carolina contracts. How do you see that? Are they, and maybe it's not that cut and dry, but are they truly North Carolina contracts because the ACC is housed there and they've got different members in all these different states, and so it only makes sense for it to happen in North Carolina? It's kind of how the judge is talking a little bit. Can you give a little color to that? I mean, and maybe if you don't agree with that, what's the other side of the coin there?
I can articulate both sides of the coin because I do see value in both sets of arguments.
Okay.
From the ACC standpoint, we are headquartered in North Carolina. We operate out of North Carolina. All of the conference members come to North Carolina for committee meetings. When we issue our funds to you, it's coming from North Carolina. We're housing the contract and all of the secret documents in North Carolina. There's a lot to be said for this being a North Carolina case. I think the strongest argument for this being a North Carolina case is if North Carolina joins the litigation party, and we now have a South Carolina member, a Florida member, and a North Carolina member, all 3 cases could and probably should be consolidated in front of Judge Bledsoe in the North Carolina Business Court. That would be the most efficient way to address this case. However, I can see value in Florida State's perspective. Our games are played in Florida. Our TV broadcasts emanate from Florida. Our board of trustees are located in Florida. And so all of the ties to this litigation involve Florida parties and Florida constituents. This is why in both cases, such hay has been made about who is the true plaintiff.
Yes.
Who filed first? Why are those things that matter? Because in litigation, generally, the plaintiff gets to pick where the forum is going to be. The plaintiff is the harmed party, and the plaintiff gets the chance to say, you all need to handle this case here to make it convenient for me because I'm the one that's suffering the harm. In North Carolina, they spent 20 or 30 minutes asking both parties about their arguments as to why they thought Florida State or the ACC is the harmed party, and both of them had some validity. We can get into those details later if you want to, but that's the basic information on the contract and the nexus. We call that the nexus of both of those states.
So a quick follow-up, and then Steve, I know I'll let you get into the next piece, but so it sounds like from what you just said, adding Clemson to this now that we know they have filed suit, and we don't know anybody else. So we'll just stick with what we know. We know FSU, we know Clemson, but at least having the two is starting down the path of where you kind of began there and saying, well, yeah, it actually maybe makes more sense to have it in North Carolina than having all of this going on in two and maybe more courts of law.
Correct.
Okay. All right.
Well, all of that leads perfectly into our next question, which is basically, can you just maybe give us a short kind of lesson, a legal lesson on just the concepts of what is priority and then also what is forum shopping and why is forum shopping bad, or at least in Judge Cooper's opinion that they look down upon that. Can you talk about those two concepts?
So priority generally favors the first filed suit. Whatever suit gets filed first is generally deferred to as the correct situs, S-I-T-U-S, or location of the case to be heard in. However, there is doctrine within that case law that says if you filed first solely for the purpose of being first in an attempt to gain a tactical advantage, we're going to discard your priority as being filed first. Florida State has obligations under the public meeting laws and the sunshine laws, which we're going to get into also, to publicize their board of trustees meeting. They can either issue, I forget what the traditional notice is, maybe 4 weeks, or they can have a short notice meeting, but they still must give at least 24 hours notice to that emergency meeting. So that's what Florida State did. They announced an emergency meeting, and then they held that meeting to discuss legal matters related to Florida State athletics. Well, once the ACC saw the public press release about Florida State meeting to discuss legal ramifications, they went ahead and filed their lawsuit in North Carolina to try to gain a tactical advantage. They clearly didn't draft the lawsuit at that moment.
Right.
It was a detailed and complex complaint. So they had it sitting in a drawer somewhere waiting for Florida State to make a move. And once Florida State made a move, the ACC went down to the court, filed it, and then served the Board of Trustees shortly after their meeting, where they, in fact, voted to start litigation. Now, Florida State's perspective is that was premature. We were having a Board of Trustees meeting. It was perfectly plausible that we would have a meeting and not vote to move forward with litigation. That's BS. We knew where this was going. I am happy to call a spade a spade. That's one of the ways I can prove my objectivity to some of you who are critical of me. There was no doubt that Florida State was going to file suit on the 21st, and that just gave the ACC the opportunity to file on the 20th. So both judges issued opinions as to whether or not that was appropriate. In North Carolina, shockingly, the North Carolina judge said that was appropriate. It was an inevitability that Florida State was going to file suit. So the ACC, protecting its interests, was not being preemptive and was not looking for a tactical advantage. However, Judge Cooper in Florida saw it differently, and you said it perfectly in your last show. They're both looking at the same thing, and they're both reaching different conclusions, and both are legally valid conclusions.
Right. Okay. I appreciate you saying that because that's where I kind of was at the end of the last show. It's like neither one, everybody wants to say the one judge is wrong. Obviously, if you're an FSU fan, you're saying, well, Bledsoe's got it wrong. He's a homer. We've seen those comments. He's Tobacco Road, blah, blah, blah. He, graduated from, was it either UNC or NC State? I think NC State. But anyway, all that stuff. And then if you're on the ACC guy, you're saying the same thing about Judge Cooper. Oh, he's right there. Da, da, da. But to me, when you look at what they're actually trying to rule on, to me, they got it. I mean, and I'm not here to judge them. They got it right or wrong, but I think their opinions were based on the facts that they had to move forward with the case. So I appreciate you bringing that up, because that was kind of my read of it, but that doesn't mean it's right or wrong. But I appreciate you confirming kind of my thoughts on that, at least. So, and on the forum shopping piece, I mean, do you see any issues? I know Judge Cooper really, and he said it. He said, I'm using a lot of patent type of cases in the past, and he went around the United States and different states and where they used all of this kind of stuff. And he also said very clearly multiple times that, hey, if there's other case law that I'm not seeing, or please forward it to me, and I'm happy to review anything. Do you find any issue with the fact? I mean, I don't think Judge Cooper is going to have an issue because he's using it in his opinion. But moving forward, if there's an appeal or anything, is there anything there with using patent cases, or you just think just the broad scope of forum shopping is it is what it is?
This is a unique case. And with it being a unique case, that means you have very few historical decisions on which to base your future decisions. This is using the legal concept of stare decisis. The idea is that the courts should follow other courts' decisions in a consistent manner. So if there is a similar case with a similar set of facts, you should be able to advise your clients, the attorney should be able to advise their clients, hey, this is what's happened before, this is how I think the judge will rule. Every once in a while, we have really broad and massive changes. Supreme Court has a history of overturning some social injustice through litigation. But as a general rule, courts should consistently evaluate cases based on prior decision or precedent.
Okay.
So here, there isn't a lot of precedent on what happens when the ACC is negligent in managing the benefits and material that they're giving. A broader discussion about other facts and whether or not they're similar. So in Judge Bledsoe's courtroom, there are some North Carolina cases that are similar, one of which, of course, is the Maryland situation from 2013. But there's been Supreme Court decisions since then that upended that law and basically said those case laws that you based your Maryland decision on are no longer valid, so they're starting over from scratch. That's why Bledsoe says there's not a lot of case law for us to base our decision on. In Judge Cooper's scenario, he recently had another patent case that came up, and that's why he had to buy this treatise that's now sitting on his desk. So it's just kind of the hip, cool thing that he's been reading lately.
Okay.
And just like all of us read the newspaper and like, hey, you'll never believe what I just read the other day. Judge Cooper's kind of doing the same thing. He's got this cool new book on his table, and he's like, hey, check out all these other cases. It is a bit of a stretch. We're not dealing with a patent case.
Yeah.
A patent case is a subset of federal cases. So it's not really analogous to what we're dealing with here. And as a result, I'm not suggesting it's an appellate issue, but in terms of validating his logic and in terms of validating his opinion, that's about as far of a stretch as you could possibly have.
Okay. All right. Interesting.
Just a quick follow-up comment to that. At the times he mentioned intellectual property when he was talking about the games and the value of those games, and I really didn't understand where he was going with that. As far as he kept coming back to it being intellectual property, and it makes a little more sense when he's trying to tie that to patent law for intellectual property.
And there is a degree of intellectual property in this case, no doubt.
Yeah.
This is copyrighted material that's being broadcast by your conference for general consumption. But what's at issue in this case is the contracts and breach of contracts. So that's why I say it's a little bit of a stretch to really base your decisions in patent law when you're talking about contract law.
Well, that's good stuff. I feel like I haven't heard that before. So
Yeah.
See, that's why everybody needs to be watching the Big Mountain, right? And appreciate Doug. We're not even halfway yet. You know what I got to get into?
What's that?
the sunniest of sunshine laws. That is in the state of Florida. Doug mentioned that earlier. He said we were going to get into it. And I want to focus, we'll start with this topic about trade secrets and confidential types of information. And we can get into more of that if we like. But I really want to know, because trade secrets is what ESPN is hanging their hat on in both cases. And we heard them talk about this in the North Carolina case. You heard that with that motion to stay and everything that Bledsoe talked about. And we haven't quite got there yet with Florida. So we're on top of maybe what happens on the 22nd a little bit. But can you describe at all how are trade secrets and or confidential agreements usually protected in the state of Florida with their sunniest of sunshine laws? I mean, how can this happen? And I'll call it what they called it in the court of law, the Florida public records laws. How I mean, to me, there's got to be some protection for these things. I get it. There's a lot of openness there. But can you help answer that question a little bit? Because, I see a lot of comments where it's just like, they're going to get everything. And I'm like, no, I don't think they're going to get everything. They'll get more than they may get in North Carolina, but it's not going to be a completely unredacted, I would think, agreement. So I'd love to hear your take on that. Oh, maybe you got something.
I was just going to say, before you answer, Doug, I just want to let you know that every commenter we've had, almost every Florida State fan who has commented, has reminded us and let us know that the state of Florida has sunshine laws. So just want to put that out there, that we are aware that the state of Florida has sunshine laws. But please give us your wisdom on that.
So to start with, to educate those who don't know, Florida sunshine laws are the broadest of all 50 states. And what it basically says is, very simply, if a state agency engages in a contract, that contract is by definition a public record. And that's to ensure that there's no backhanded dealing, that there's no under the table deals, there's no nepotism going on. Florida State has a, unfortunately, very rich history and tradition of a lot of inside dealing. And so the legislature cracked down on this, probably overreacted, and made it such that the default is that if you sign a contract and you're an actor or agent of the state of Florida, it is by default a matter of public record. Now, Florida is one of 48 states that has signed on to the Uniform Trade Secrets Act. And so what that means is that there are protections in place for legitimate trade secrets. Now, that's key. The judge is afforded what's called an in-camera review to have the opportunity to review that information before it is made public. So this is one of the biggest contrasts between the two litigations from the very beginning. When the ACC filed their initial complaint and their subsequent amended complaint and included their exhibits, they had a lot of exhibits under seal. They had a lot of portions of their complaint redacted. In fact, the North Carolina court actually screwed up because initially they published an unredacted version of the complaint before pulling it off their website. Matt Baker is one of the great journalists in Tampa Bay that's handling this. He got a copy of the unredacted version before it was pulled down. And then they put up a redacted version of the complaint. By contrast, Florida State was like, screw you guys, we're putting it all out there. Everything's out. So they didn't have anything protected. They didn't have anything sealed. They didn't have anything redacted. And ESPN and ACC have responded in a not so kind manner to that. So going back to your fundamental question, yes, there are protections for what are true trade secrets. The question is, what is in fact a trade secret? So this came up in the North Carolina hearing, where it was noted by the Florida State attorneys, King in particular, that 18 of 160 pages of the ESPN agreement were made available in the litigation in ACC. And so the position of Florida State is, look, we can't consent to an order of protection, because that's what the ACC and ESPN want. We can't consent to an order of protection because that would cause me to break Florida laws. I'm required to oblige Florida laws. Florida laws say it must be made public unless a judge issues an order of protection. So that's where we're fighting on next. That's the next big battleground, is what is Judge Cooper going to do with this request to keep the majority of the ESPN agreement as a trade secret.
Okay. All right. That's good stuff. Because I've looked a little bit into the Florida Public Records Act just a little bit. And I appreciate you kind of dumbing it down for at least me on this to have a better understanding. But yeah, I mean, that's one of the biggest, to me, one of the biggest questions here is how much are they going to be able to protect this agreement?
Let me throw a huge asterisk into this conversation, because early on there was talk about, could FSU and ACC reach an agreement and a settlement? And obviously that's the most likely outcome in this scenario. But was there a way for Florida State and the ACC to reach a quiet, private settlement that wouldn't be made public? Is there a number that Florida State could pay, but then not disclose, to run the risk that other members then have just asked to pay the same number? And truthfully, I don't believe there's any way that Florida sunshine laws will allow any type of NDA or protection in any settlement between Florida State and the ACC. So if and when there is an agreement, it's going to be a public agreement that the other members are going to know about.
Interesting. Okay. Wow. That's good stuff too. Yeah. Ready to go to number 4?
Yeah, great stuff, Doug. And honestly, again, a nice segue right into the next topic, which is, so there seems to be, we have Florida public records laws, we have North Carolina laws. I keep seeing this topic being thrown around of the conflict of laws. And from what I understand, that could be, 2 laws in one state that could have a conflict, or it could be laws in 2 different states where there could be a conflict. So I just wanted you to just talk about that concept of conflict of laws, and then also just kind of give us an idea of where that could lead. Could this, if basically the law in Florida says one thing and the law in North Carolina says the other thing, and the judges are sticking to the law and the precedents in their states, could this end up having to go to federal court? Is that a possibility? Do you see that down the road?
So that's actually about 9 different questions rolled into one.
That's
so
how
we'll
I roll.
Try and unpack that.
Yeah.
So I assume that one of your readers or one of your watchers prompted you on this idea of the conflict of laws. And I think they may have been confused with something called the choice of law provision. So that's 2 different things, and we'll get into both of those. The conflict of laws is, you took me back to literally second year of law school, because that is a scenario where if there is a true conflict between the states, or more commonly, a conflict between international parties, how is that resolved? And there's a long list of ways that those situations are resolved. Other than the sunshine laws, I will tell you, the laws between the states of North Carolina and Florida are very similar with respect to contracts. So there's not going to be a conflict of law situation, because whichever court holds court over this case will apply most likely a majority of Florida laws to this contract, because of the way that the party is Florida State involved in this contract. So even if this is a North Carolina case, the North Carolina judge can look to and interpret Florida law. Now, in contract law, there's frequently this idea of a choice of law provision, which is written into most contracts. That's one of the negligent moments that I see in this ACC contract that was provided. You're dealing with 13 members in 7, 8 different states. How do you not write into your membership agreement a choice of law provision saying any and all disputes are going to be handled under North Carolina law in a North Carolina court? It would have been a very simple paragraph to add, and it is located in most contracts involving national litigation. So that was the first mistake that I believe the ACC made, is not including a choice of law provision. Now, you mentioned federal court. Let's talk about that for a moment. What is the likelihood there? For a long time, I did not know the answer to this question. I still am not certain that I can grasp and understand this question. Where I am today on your show in April is, if there was a true federal question involving diversity jurisdiction, diversity of the parties, there is a way to have a federal removal but either or both parties need to request removal within 30 days of being served with the complaint. We're well beyond 30 days, so that period has lapsed. There is a way that can still happen down the road, but now there would need to be a federal question in the litigation. So one of your readers had mentioned at one point the Major League Baseball antitrust litigation. Well, that was involving antitrust issues. That's why the New York Yankees and the MLB suit went to the federal court, because now we're talking about federal issues. There's no federal issues in this case right now. So I don't see diversity jurisdiction causing a federal case. I don't see a federal question causing a federal issue in this case. So I have backed off on my previous opinion that this was heading to federal court, because I'm now siding with those parties that say there's no mechanism, there's no procedural way at this point for this to become a federal suit.
So I have a follow-up to that, Doug. I've seen some people mention about a Florida statute that basically says that a state entity, a state institution, cannot pay any fines or judgments against them over a certain value without approval from the Florida state, the state of Florida, the legislature. So could there be could a situation arise where a North Carolina judge finds on behalf of the ACC, and they say, Florida State, you have to pay X amount of dollars, and the state of Florida says no, they cannot. Florida State University, you cannot pay this amount. Would that then become a conflict between the states that could go to federal court, or are we just getting way too far ahead of ourselves on that?
Look, there are no bad questions. This is very, very fascinating stuff, and part of the reason why I'm sitting here tonight hanging out with you all for a while to go over this. There are no bad questions. The statute you refer to deals specifically with cases in tort, not contract law. So there is a $250,000 cap where an entity in Florida can be sued in tort, and any amount over that must have legislative approval. So that wouldn't apply here in this situation. I had another thought that no longer fits in my brain or train of thought, so I don't know where it went, but I'm sure if I think about it later, I'll bring it back up. But to your point, no, there is no cap in terms of the question of how much might exist in that situation.
Well, the other one here, we're wrapping it up, and I want to thank you, Doug, for allowing this much time with us. We really do appreciate it. I mean,
Sure.
It's entertaining for us. We enjoy it. I feel like I'm learning every time we do this. I actually do enjoy reading the briefs, even if they're 78 pages or 130, whatever they are. It's just really interesting to dive into this. I didn't go to law school. I don't think I ever would have made it, but I do enjoy reading some of this stuff.
Yeah, so we appreciate the opportunity cost of your billable hours that you're giving up for us right now.
So the last one I'll talk, sovereign immunity, the big one here, sovereign immunity. Can you talk about that obviously in the state of Florida? That's come up in both hearings, in both cases so far. And can you then explain the difference maybe between explicit and implicit? Because we heard about that through Judge Cooper as well.
So the sovereign immunity statute is based on kind of the same thing we were just talking about, with certain limitations in suing state actors. Florida State Board of Trustees is a state entity, and in order for them to be sued, they have to give permission to be sued in the written contracts that they offer. So that's the explicit nature. Now, there are circumstances where you don't include explicit language, and the Supreme Court of Florida has interpreted that there are implicit times where a party can be sued, but it's specifically for breach of contract. Now, that requires a proper contract, proper consideration, proper execution, and that may or may not be one of the issues that come up later on in this litigation. But the idea is that either the contract must say that there is explicitly a waiver of sovereign immunity, or under certain circumstances, there's an implicit waiver as long as certain preconditions are met. Now, when North Carolina sued Florida State, or the ACC sued Florida State in North Carolina, one of the first things that the attorneys tried to argue was that that sovereign immunity statute only allowed for litigation within the state of Florida. And here's the second opportunity for me to be objective and call BS.
Right.
There is no magic line on the northern border of the state of Florida that says a entity can only be sued in the state of Florida. The statute says in any court, not in any court in Florida. If the legislature wanted to limit it to Florida, they would have written the statute to say in any court in Florida. And the fact that the legislature didn't say in any court in Florida affords courts the opportunity to interpret it as in any court, including those not in Florida. So the the sovereign immunity statute does not provide protection from any suit taking place in North Carolina.
Okay. All right. And I feel like, and Steve was the one that was able to listen to the entire or almost the entire hearing the other week down with Judge Cooper. And this came up in the hearing. Yeah. And I think the judge was kind of open to this, was he not? Or
if I remember correctly, Judge Cooper said that he was under the impression, it was his understanding that it would have to be an explicit waiver, but it's possible maybe I just didn't understand what he was talking about, where he was going, because that was towards the end when he's reading from notebooks, whatever. But I'm pretty sure.
That's the statute says, to your point, the statute says the waiver of sovereign immunity must be explicitly stated in the contract. But the Supreme Court of Florida has rendered decisions that have said there are occasions where an implicit waiver is possible. Now, maybe I'll be corrected. Maybe somebody will pull up some other case law that came later on. I haven't researched all the case law and all the issues. I'm not one of the attorneys arguing in front of Judge Cooper. But as I understand it, the way the law currently states is the statute says it must be an explicit waiver. But we have some Supreme Court of Florida decisions that say there are occasions where an implicit waiver is allowed. It just has to meet certain basic conditions.
Okay. All right. And I'll say that's one of the things, the toughest part about following these cases, in my opinion, is, like you mentioned, North Carolina law and Florida law, a lot of similarities. But the way the judges are ruling, they're looking at precedents in their states. And, Judge Bledsoe was very clear. He wanted to make a decision that was going to hold up to the appeals court in his state, and that would basically hold up to the Supreme Court in his state. And I think Judge Cooper kind of in a more roundabout way said the same thing. So it's kind of, it's kind of difficult to predict when you can't just look at the laws, the statutes. It's also about the precedents and what has happened and what's been actually upheld in the two different states. And I think that's why you can get such a different perspective from Judge Cooper to Judge Bledsoe. And a lot of it, I feel like both of those judges, and you would know this much better than we would, but I feel like a lot of what they were saying in court wasn't just to the parties that were in the courtroom. It was more directed at explaining their reasoning to the appeals court and potentially the Supreme Court in their state as to the reasons of their thinking.
Yeah, Judge Bledsoe had a great line in his hearing basically saying, look, they checked my homework too.
Yeah, right.
And I got a chuckle out of the courtroom. But that's truthful. Not only is it for the purpose of the Court of Appeals, we'll call that the upstream, as the ESPN attorneys were talking about the upstream content, but then you also have the downstream content. The judges are both encouraging this to not result in a full-blown trial. Yeah. Both judges would like to see these cases resolved through some form of settlement. The problem with litigation, and the reason why 98% of cases do not end in a judgment, but rather in a settlement, is because it's either 100% win or 100% loss. Judges don't get to compromise. Judges are forced and required to draw lines in the sand and say 100% yes or 100% no. And so that's why judges truthfully, honestly, would rather see cases come off their dockets because of a settlement than have to rule to a judgment. Even though that's their job and that's what they're called to do, that's not their first choice of how to see these cases end up.
And we saw that JY and I were covering in the PAC in Washington State, Judge Levy, and we saw that where he was encouraging them to come to a settlement because he said, you know, I'm going to rule one way or the other, and one side is going to be really, really unhappy. So, and you guys don't know which it's going to be. So I would encourage you to come to a settlement. And eventually they ended up coming to a settlement. But from what we said the whole time was that settlement didn't come until the other members of the PAC had lost, you know, basically had lost motions, had, you know,
Right.
a couple, and then the Washington State Supreme Court didn't take on the case. So basically they lost 2 or 3 in a row and they were behind. And so they had that incentive to settle. In this case, do you see either party in jeopardy or at risk where they might be motivated to settle? Or do you see both sides basically still going full bore at this point?
It's a great question, a great point. And more importantly for me and my sanity, you jogged my memory on what that other point was that I wanted to make a few minutes ago. When you're talking about the amount in controversy, what happens when the legislature has to get involved for an amount over that doesn't necessarily apply to this situation. What that sparked was a conversation about taking a step back. Remember, I've seen a lot of people that are mad at Florida State for suing, or you know, you're just a bunch of crybabies or whiny babies. Take a step back and understand. Florida State is not going to get hit with a judgment for $574 million.
Right.
That's not at stake here. What's at stake here is the status quo. If Florida State loses, then Florida State is stuck in the ACC until 2036 and can't do anything about it. So when it comes to your question about whether or not there will be a settlement, I wholeheartedly believe there will be. The risk in this litigation is with the ACC. The ACC, due to their own poor management and mismanagement and nepotism and internal prosperity, they've focused on the success of the ACC and not on the membership. And no, the college football playoffs is not why Florida State initiated this litigation, but it was the final straw in the recognition that the ACC views itself as a second tier conference. And if ACC is not willing to fight for the undefeated Florida State team with an injured quarterback to get into that playoff, then ACC is acquiescing and relegating themselves to second tier status. And that was confirmed 8 weeks later when they accepted a compromised share of the playoff portion. So the ACC has already made its determination that we're not on the same level as the SEC and Big Ten. Florida State's position is that is malfeasance, and you have mismanaged the properties that you were given. Every conference has 1 or 2 stellar programs. Every conference has 3 or 4 secondary programs that go up and down throughout the years. You have failed to capitalize, and you have failed to push the ACC into a conversation where we're not the SEC. We know that. We're not the Big Ten, but we could be if Miami would get its act together, if Virginia could consistently perform, if Clemson cannot fall off the wagon next year, then yeah, we've got 4 or 5 decent properties that are equal to not Alabama and Georgia, but Ole Miss and Auburn and LSU. And if you can say that we're just slightly below the other conferences, then there's value in our program, value in our conference. But because you failed to stand up and assert a 13-0 Florida State as an equal partner, you, ACC, have given up on the idea that we're equal partners with these other conferences. And that's why the litigation is moving forward, not because of the snub, but the snub is just the nail in the coffin that validated what we have been saying all along, which is the ACC is not doing the job they're supposed to be doing.
Yeah, well said. Well said. You articulated that very, very well, I think. So I have a fun question to end. I don't know if you have anything else. I have something that's kind of fun that I want to get to. Something else?
Yeah, before you go to the fun question, I'll just say what you just said. You know, we've been focusing on venue, priority, forum shopping, but that was a great way to just kind of bring everyone back to what the stakes of this case are
Yeah.
and what it's really about, because we've been focusing on this procedural stuff so much and so much in depth. And I appreciate you bringing us back to what the whole case is about.
For sure. So kind of a fun one to close us out here. I'm going to ask you to read your crystal ball if you're willing. And I want you to give us your thoughts of what's going to happen here on the 22nd. I know he still wants to talk. Judge Cooper mentioned, obviously, he has the motion to dismiss that he has to talk about. He has the motion to stay discovery that he has to talk about. He brought up some other things, rightness and some other stuff. Do you have any tells so far, or where you think this might be headed here next week?
So there was a question, and you guys talked about it also. Why did he bring up the motion to stay first and not the motion to dismiss first?
Yeah.
The motion to dismiss is an impossible standard. And in fact, that was one of the things that happened in North Carolina that gives me some confidence that Judge Bledsoe can be a level-headed, reasonable person. In North Carolina, the ACC alleged that Florida State owed a fiduciary duty to the conference. And Judge Bledsoe dismissed that complaint because there is no fiduciary duty that a member owes to the conference. The standard, though, is so high for a dismissal that what you're saying is everything that's in the pleadings is true. If everything the ACC says is true, is there a valid claim here? And the answer to that is no. So in the Florida case, the judge already knew, I'm not going to dismiss this case.
Okay, yeah.
So I'm going to rule on the motion to stay first because that's a lower standard. Should this case, now that we have the ruling from Judge Bledsoe, should this case be paused? And that's a much lower standard. And even then, the judge said no. So now he's going to get to the motion to dismiss, which he's going to deny. The motion to stay discovery, which he's going to say, no, we're not dismissing it, so we're not going to stay discovery. And now both cases are going to be on parallel tracks. And now is when you get into constitutional questions about the full faith and credit clause. That's why there is going to be a race between both jurisdictions as to who can come to a conclusion first, because if this is not a federal case, if this remains a state case, the decision of one state court must be recognized and ratified by the other states when a conclusion is drawn. So there's still a lot of appeals to go. And no, I don't think that either of these cases are going to get to a judgment in either case, but that's where the procedural tracks are going. What is likely to happen, my crystal ball, where are we headed? I think the Florida state would be willing to accept a compromise anywhere between 150 million to 180 million. That's the 130 to 140 million dollar exit fee plus some additional. And I think that part of the compromise is that the announcement of the deal is after April 15th, because that's the date when a conference member has to announce their departure.
Right.
That's the third thing that I can call BS on for Florida State. They said throughout their complaint, we want to relate back our exit to August of 2021, 2023. No, that's not going to happen.
Try. I mean, what's the harm trying?
Yeah. So August 16th is the after August 15th. And then we kick off in Ireland against Georgia Tech on August 24th. So I would not be shocked if in that window, that week, there is an announcement of a compromise settlement in the 150 to 180 million dollar range.
Interesting. You went deeper than I thought you were going to. So I appreciate that. That's great. So yeah.
So Doug, before I think you're off, I think you're out of the hot seat now. I don't think we have any more direct questions for you. But what I just want to say is, well, first of all, you have, and I'm sure JY will agree, you have a standing invitation. Anytime you want to come on here, talk about this case, talk about Florida State, ACC, you've got a standing invitation. Now, on top of that, I want to extend you a further invitation, something we haven't done yet for anybody. I don't think so.
Okay.
So the reason we started this show is we pick games. You know, I do the Big Ten, JY does the Mountain West, just for fun, for entertainment purposes. So during the season, we pick those games. I'd love to have you on some week next year, if that's allowable, if you're able to do that for entertainment purposes, just for fun, be a guest picker. You know, Sports Center brings in their guest picker.
Yeah.
we don't have the budget to fly you in on a helicopter, but we do have a Zoom subscription for a year.
Mhm.
So we'll bring you on if you want to. You have the open invitation anytime next season. You want to come in, you want to pick games. I picked the Big Ten, but I'm going to be picking Florida State this year and maybe Clemson because I have just this inkling that we may see them in the Big Ten here the next few years to see. So if you want to come in and just pick a Florida State game or any other games you want to pick, we'd love to have you some week next year. You can be a guest picker for us.
That's a great idea.
That would be great. Mm-hmm.
I didn't talk about this with
storyline.
I didn't know where he was going at all. So
yeah, there's a great storyline there with DJU Uyunglele.
Yeah.
I've been practicing. Coming from Clemson, going through Oregon State, and now joining Florida State. That's going to be a great national storyline to watch. And I believe in Mike. Mike's got us, and Tony Tokar is our quarterback coach. They are the real deal. They turned a running wide receiver tight end and Jordan Travis into a legitimate Heisman contender before his broken leg. So I'm trusting them to do the same thing with DJU and turn him into the next first round pick out of Florida State.
There you go.
And that defense, I mean, I know they're losing some players to the NFL, all good teams, that happens, but that defense last year, honestly, and it's a shame what happened with the quarterback and everything that went down. Because honestly, I mean, I've been watching college football a long time. You and I are about the same age. That is one of the best defenses I have ever seen, that Florida State defense last year. And I don't think they got enough credit. And they were kept out of the playoff, possibly having a historically great defense, right, to me on par with the Georgia defenses the last couple of years.
I couldn't love you more.
Well, with that wonderful ending, I think we'll end it there. Again, we want to really thank you for your time here and letting us run. I don't know what we're at here now, but it's been for quite a while. So thank you for doing this. I'm glad we could make it work. As Steve said, depending on what happens here, we'd love to we'll definitely stay in touch via Twitter. We'll be following you.
Absolutely.
And all of that. But we want to thank you for coming on the Big Mountain here. It was a great episode. Hopefully our viewers enjoy it. So
my pleasure. You all take care. Have a good one.
All right.
Take care, Doug.
Well, we really want to thank Doug for being on here again. Great conversation. And that's what we like to do here on the Big Mountain, is have the conversation. Follow him on X. He does all kinds of good stuff on there following these cases. He's on top of it. I know we like to follow him. He gets all kinds of tweets out. Do they call them tweets anymore? X is out? I don't know.
I still call it Twitter and tweets and whatever. Twitter X.
He's pretty active on there, so make sure you give him a follow. Make sure you give this episode a like. Subscribe if you like our content. We'll see you guys next time on the Big Mountain.